And then finally, tomorrow brings an important legal challenge in Thurston County Superior Court to the income tax repeal initiative and that public investment impact disclosure statement from the Attorney General that will appear alongside Initiative 645. And the legal challenge is based on the fact that those folks say this PIID is anything but unbiased, and they also argue it's factually inaccurate. And that's what the case that they will make before this Thurston County Superior Court judge on Friday. Now, a PIID, which was passed by state lawmakers a few years back, is supposed to describe how a ballot measure, in this case, an initiative, changes state taxes or fees and impacts the state budget. So, eventually there will be revenue from the income tax that could, if it's repealed, impact the state budget. But again, those statements are supposed to be neutral and accurate. Now, the challenger in this case is a man by the name of Arthur West, and he believes that the PIIDs have been weaponized by the AG's office to make voters think that if the initiative, the income tax repeal, is in fact adopted, the consequences will be dire. So here's that challenger, Arthur West.
The principle is separation of powers in Washington now has taken on a new form, which is stronger and protects against incursions into coordinate branches. And the people, when in adopting legislation, have reserved their right to act as a coordinate branch and to have the executive write in portions of a law and insert them into the ballot title after it's been certified. Is just crazy in my view. I don't see how that could possibly stand constitutional muster, but could go either way. You never can tell what's going to happen in court.
Mr. West sent me a copy of the argument that his attorneys will be making on Friday, and it says this in part: this case is not about whether voters should know an initiative's fiscal consequences. Plaintiff agrees they should. This case is about something far more troubling, whether the government, under a false flag of informing the public and regulating the initiative process, can instead insert false, politically charged propaganda into the ballot title itself immediately before voters cast their vote for one category of initiatives only, chosen by their political content. So he believes, again, that statement is politically charged and factually inaccurate. And those arguments will play out in court tomorrow. Now, I was told by GOP Chairman Jim Walsh this week that the judge may very well issue a rewrite right there on the spot at the conclusion of that hearing. They could also take the recommendation of the challengers for how it should be reworded, or the judge could simply say there's no issue with the PIID as issued by the AG, and that's how it's going to appear on the ballot. There's urgency here because August 21 is the final date for all of the ballot language to be finalized as they prep the voters' pamphlets, and they have to get those ballots printed up well in advance of the November election to get those overseas ballots sent out and such. So we're going to be following that very closely on Friday, and stay tuned for updates for certain. All right, let's dive in. Plenty of attention today on Thurston County Superior Court, where supporters of the initiative sponsored by Let's Go Washington that hopes to repeal the new income tax are in court trying to convince a judge that the impact disclosure statement, the PIID as it's called, that'll appear next to Initiative 645, is not impartial, is not unbiased, and is incorrect, factually inaccurate. The initiative, a reminder from Let's Go Washington, would repeal the recently adopted 9.9% tax on income above $1 million. Or if you're a husband and wife and together you make more than $1 million, whatever that threshold is above that, you're going to pay that nearly 10% tax on. It would keep, though, if this initiative repeals that, what it would leave intact is the expansion of the working families tax credit. So average Washington families would get more money back plus the higher income earners over $1 million wouldn't be subjected to this tax. It would also preclude any local governments from passing future income taxes, adopting their own. Seattle's done their thing, and other cities have certainly looked at potential versions of wealth tax. So this would preclude some of that. But next to that initiative on the ballot is going to appear this public investment impact disclosure statement. And basically, it's a warning of what this is going to do. If you pass this initiative, this is how it impacts state government. The problem, according to the legal challengers here, is what the disclosure says. And here's what the disclosure says. I'll read this for you. This measure would decrease funding for public K-12 education, higher education, including universities and community colleges, and human services, primarily healthcare. Now, again, challengers say, how can that be when there's no revenue to take and to cut from these? Future, they could put money into it, but as the income tax legislation was written, there's no guarantee for where any of that money goes. It could well go to the general fund. You could have budget writers, making decisions down the line about what really needs the income tax revenue rather than education, rather than healthcare. Now, there's a separate legal challenge as well from Let's Go Washington. They've challenged the statement in court, along with another private individual, calling it, again, misleading, arguing it speculates on this future funding for money that isn't yet collected. And Let's Go Washington had this to say about it. Brian Haywood, the founder of Let's Go Washington, said, "You can't cut money that doesn't exist. The Attorney General's PIID is not just misleading, it's factually inaccurate or incorrect," said Brian Haywood. I-645 does not decrease funding at all in the current budget cycle. In fact, it increases funding by returning millions of taxpayer dollars that would have been spent setting up an income tax bureaucracy and defending an unconstitutional income tax against legal challenges. That bureaucracy he's referring to is right in the legislation for the income tax. It funds the Department of Revenue hiring a whole bunch of people that are going to have to, new government employees that are going to have to administer, to keep track of who the wealthy people are, where the money comes in, and, track all of that. So that's the bureaucracy he was referring to. Now I want to play some comments from Republican Party Chairman Jim Walsh in a conversation earlier this week where we were discussing this challenge to the PIID.
The whole PIID concept is controversial. It's basically been weaponized by the state attorney general's office, who's charged with writing the 15 to 18 word description. And first it was Ferguson, now it's Nick Brown. The two successive state attorney generals have completely manipulated this thing. The idea of the PIID is it is transparency. It says what the likely impact of the initiative will be. But they lie. They're saying that it does things. In this case, they're saying that the initiative to repeal the state income tax will cause a reduction in spending on K-12 schools, on higher ed, on human services. And that is a lie. It doesn't do that. And so the state party, the state GOP, has filed an amicus brief to the lawsuit filed by Let's Go Washington, disputing the wording of Nick Brown's 15 to 18 word description of this initiative. And as we point out in the amicus filing that the court will read and consider this week, we demonstrate with direct links to the Office of Financial Management and the budgets of the state of Washington that the statement in Nick Brown's description is a lie. It is wrong. And so we use the OFM is the agency under the governor's office that writes the budgets for the governor and manages budgets. We use their own data to show that Nick Brown's description of this initiative is a lie. It's false. And we're hoping that the judge in Thurston County will rewrite the 15 to 18 word description, which the judge in Thurston County, Superior Court judge, by law is allowed to do.
Now, as we shared in Thursday's episode, it could be the judge deciding on the spot after today's arguments. Chairman Walsh said that's up to the judge. The judge could say, Yeah, I'm going to rewrite this thing on my own. It's like 15 to 18 words, or I saw another source today that said it was like 21 words at max. But the judge could right there rewrite it and say, no, this actually seems like a more fair statement that should appear next to the initiative. Judge could take the recommendation of these Republican challengers, Let's Go Washington supporters as well. I've said this is what it should say to be fair and accurate, or could say simply it's fine as it is, the way the AG wrote it, and let that go to the ballot next to the initiative. If there is not a decision right away, I've been told it would come as soon as Monday. So we're going to be watching for that. And our Washington state editor, Andrew Paxton, is closely following this argument today. He's going to be putting up an article following the hearing with exclusive reaction from participants on our Center Square Washington page. So I encourage you to check that out for far more detail. And now the Building Industry Association of Washington, BIAW, is actively encouraging people to contact the State Building Code Council before midnight tonight, because SBCC is updating 2024 through 2026 energy codes. And this refers to a whole lot of things about forced electrification in your house, about how efficiency standards are posted for the public. It's nice. You go to buy a new fridge and you can see, how energy efficient it is. So some of these are not objectionable to BIAW, but others are. Specifically, code provisions that penalize natural gas use and then drive up construction costs. Now, you may recall that voters passed Initiative 2066, saying they wanted to keep natural gas as an energy choice. But then there was a legal challenge to that, and a King County Superior Court judge ruled it to be unconstitutional, basically saying voters were confused. There was more than a single subject, and they didn't know what they were voting on. There was then an appeal from BIAW to the state Supreme Court, and those arguments happened back in January of this year. And there will be a ruling. We were hoping it was going to come before summer, but it likely will be maybe early fall when we get that ruling from the state Supreme Court on 2066. And BIAW says in the meantime, the State Building Code Council shouldn't be doing things to disincentivize natural gas, while the state Supreme Court may very well say, you can't do that. You have to let people keep natural gas as an energy choice. So here is Greg Lane, Vice President of the Building Industry Association of Washington, talking about his concerns with SBCC, and he shares what they are most concerned about.
But there's a couple really bad proposals that they're moving forward with. One is doubling down, as I said, on the costs associated with prohibiting or greatly disincentivizing the use of natural gas. And they're adding additional requirements into the adoption of electric heat pumps into the code that will add another $1,000 to $1,500 per unit, and the payback on that is over 50 years, which no one owns their home for that long. So again, that cost just goes on to the cost of building the house, and the buyers eat that cost, and they're never going to see any savings. And especially as we've watched and you've reported on the dramatic increases in electricity rates that have been coming out from Puget Sound Energy and other energy providers, as the demand for more electricity grows under these regulations. As we predicted, the cost of electricity is dramatically increasing across all of the Puget Sound area in particular, but also in Eastern Washington. And that's only going to continue to increase the more that we push people into full electrification. So not only do they have the cost of transitioning their home to all electric appliances, but the cost of providing electricity in their home is dramatically increasing as well.
Now, today brings one final public hearing. It's actually happening at City Hall in Spokane. It is a day-long hearing, so depending upon what time you're watching this podcast, it may still be going on. That's going to be in person as well as Zoom. I double-checked on that this morning because with all the fires in Spokane, they were considering potentially just making it an all Zoom meeting, but people can still show up at Spokane City Hall, and you can ask to provide public comment, feedback about all these proposed code changes for SBCC, or you can provide written comments. But again, the deadline is just shy of midnight tonight. You can also participate via Zoom, I should say, and there is a link to the Zoom conference going on through the day today in Spokane up on the SBC site. It's sbcc.wa.gov. So sbcc.wa.gov. And one other note, I've also learned that there are concerns from some members of SBCC that some of the code revision language may have been changed throughout this public comment period. And that could mean that comments that were made on earlier versions, people don't now realize that that's been changed during the process. And according to one member that I spoke with, that violates Washington's administrative code. And so that could certainly become an issue in the not so distant future. And there is some suggestion that maybe SBCC needs to hold off, maybe hold some more public hearings on this, make sure everybody's on the same page as to what the current status of all these code revisions are. And there are many. And if you're curious and need some weekend reading or something, again, you can check out the SBCC site for all those details. So that's it for today's episode of Washington in Focus Daily for this Friday, August the 7th. As always, thank you for watching, like, and subscribe. And I hope we get to see you again on Monday.